our current finance minister could have put NIB through the same process, right? But instead of using money to collapse a bank, the Honorable Atuforsin has used the money to revive it, for it to keep jobs and then continue to operate in the banking sector. That is what is called wisdom in governance. Do for N7 arrests. And secondly, give an update on the ongoing investigations and prosecutions that I have initiated upon assuming office as Attorney General. On Tuesday, 22nd July 2025, I took the decision to enter a nolle prosequi in the case of the Republic versus Kobina Dufour and 7 others. This decision effectively brought to an end the criminal trial of Dr. Kobina Dufour, a former governor of the Bank of Ghana and former Minister for Finance. I took that decision after a prolonged period of negotiations with my team of state attorneys, including the Director of Public Prosecutions and the receiver of Unibank on the one side. The team on the other side was made up of Dr. Dufour, the shareholders, directors and managers of Unibank, and the receiver. As part of my constitutional duty to account to you, my fellow countrymen, I wish to provide further details on my decision for 2 reasons. First, I have always maintained that as your Attorney General, I owe you a duty to act transparently. Second, I think it is important to dispel certain misimpressions that arose as a result of the rather terse press release that I issued following the filing of the nolle prosequi. My fellow countrymen and women, in March this year, the lawyers for the Unibank directors and shareholders approached me with a proposal of their clients' intention to settle their indebtedness to Unibank. In response, I convened a meeting on the 25th of March with them, their legal representatives, and the receiver of Unibank, Mr. Ni Amano Dodu. At the meeting, first, Dr. Kobina Dufour and the other persons standing trial were not charged with stealing or looting of public funds. They were charged with causing financial loss to the state, fraudulent breach of trust, falsification of accounts, as I pointed out earlier, dishonestly receiving, and money laundering. Have approached my office for plea negotiations, including 3 former officers of the National Service Authority. Some officials have offered to testify against their colleagues, and some vendors and service providers are willing to come clean and testify as prosecution witnesses. You know, when you build your docket well, this is the result that you get. 8, people are willing to testify. Persons, they are not coming to say hearsay. They are not coming to give hearsay evidence. People who were involved, okay? And we are, in negotiations with them and their lawyers, as a precondition, I tell them, you bring back the money that we have calculated that you took, you serve as a prosecution witness. That is the approach that we are using. Now, I'm sure the MPP would be very happy for me to insist that 100% be returned to the Attorney General before any deal can be, cut. On the other hand, should the matter have continued in court, it would likely have faced prolonged delays, including multiple procedural applications, adjournments, and appeals. Even if judgment were eventually obtained in either the civil or criminal proceedings, enforcement and execution could take years, further deferring any meaningful recovery. It is clear from the foregoing that I took a pragmatic, holistic approach by engaging the receiver and the accused persons to broker a resolution that settles both the criminal and civil dimensions of the case. This strategy recognizes that while criminal proceedings are punitive, the real economic value to the state lies in a non-conviction-based asset recovery approach. The terms of the settlement are structured to ensure that the Attorney General, the Bank of Ghana, the Minister of Finance exercise oversight over the recovery of the negotiated amounts. Progress under the agreement will be subject to quarterly reviews to ensure that the accused persons fulfill their obligations as agreed. Ladies and gentlemen of the media and my fellow countrymen and women, it is important to correct certain misunderstandings or distortions, deliberate in some cases, that our team picked from the media space regarding this matter. Since my press release, it has been said that by setting a minimum threshold of 60% for the recovery of assets as a condition for filing a nolli prosperi or terminating the banking sector cases, I have cut a deal which permits persons who have stolen or looted public funds to walk away with 40% of the loot. At least that is the narrative, by some sections of, the Ghanaian populace, particularly from our opponents in the NPP who were responsible for all this mess. Indeed, one writer on Facebook compared my decision to the situation where someone has stolen 6 goods and is being told by the prosecutor to return 4 goods and keep the 2. But my fellow countrymen and women, now this may seem like a joke, but it's a very serious expression of the sense of justice of our community. And it is something that I have used, to, get people who have come to me for pleadings to get them to think about the community's sense of justice. So, it is not lost on me, and I wasn't surprised when I read this on Facebook. But the goat thief analogy, intriguing though it may be, is an oversimplification of the matter. This is why. First, Dr. Kobina Dufo and the other persons standing trial were not charged with stealing or looting of public funds. They were charged with causing financial loss to the state, fraudulent breach of trust, falsification of accounts, as I pointed out earlier, dishonestly receiving, and money laundering. But the facts and the evidence supporting these charges never allege that those standing trial personally benefited from the banking transactions that gave rise to these charges. Now, it's important to make clear that when someone is charged with, for instance, causing financial loss to the state, all right, it does not imply, from a criminal liability point of view, that they took the resources that have been lost. In other words, what we seek to do when we charge someone with causing financial loss to the state is to prove that they either intentionally or recklessly or negligently cause the state to lose resources or to lose funds. All right. Now, those of you who are old enough to remember the Quality Grain case, which went all the way to the Supreme Court, involving the former Deputy Minister of Finance, Victor Salome, and a number of NDC officials in the Rawlings regime. You will remember that in that case, Justice Afrel was at pains to point out that though the accused persons had been convicted of the offense of causing financial loss to the state, they had not been convicted of stealing. They had not been convicted of personally benefiting from the actions that were the subject matter of the criminal charges. All right. We must also understand that though the charge of fraudulent breach of trust is closely related to the charge of stealing, the facts and the evidence didn't show, that in this particular case, they fraudulently breached their trust because they stood to benefit. They entered into transactions with third parties, which pointed to the fact that according to the case that was filed, they were trustees of depositors' funds. Now, which in itself is legally contestable, right? Because the banker-customer relationship is not one of trusteeship; it is one of contract. Now, that is legally, established in case law. There are case law precedents to the effect that that relationship is not one of trusteeship. So when someone deposits their money in a bank, all right, they are not keeping the money, they are not giving the money to the bank to be held in trust. So that if that were the case, then the beneficiary would be the one dictating how the monies, should be used. But banks are at liberty, because it's a contractual relation, a commercial relationship, at liberty to lend the monies, do, banking transactions with those funds in the way that they see fit, but in a prudential manner. Okay? So, the basic point I'm trying to make is that these charges were themselves legally contestable. Alright? Second, the analogy assumes that these charges, that the goat thief analogy, assumes that these charges could be proven beyond reasonable doubt. On the contrary, the record shows that the charges were contestable, and there was a high likelihood that the defense could have raised sufficient doubt to procure an acquittal. And if that happened, as seen from the Beige capital case, I would not have been able to recover even one cent. Now, ladies and gentlemen of the media, and my fellow countrymen and women, when I did the press release, I did not mention Beige capital because at that point in time, I did not know that the decision was coming down. Now, as providence would have it, the decision came a day after, right? I can now disclose that Beige capital offered me or my office 10 million Ghana cedis. You can ask the lawyers for Beige capital. Ask lawyer, Tadio Sore. They offered 10 million Ghana cedis in settlement, and I refused. Today, I can't get 50 pesos from Beige capital. So the dynamics are complex. Those who are oversimplifying it and saying this is the good, thief scenario, must understand that it is more complex than just saying that the Attorney General says bring 4 goats and then keep 2. Third, by the time I assumed office and was approached by the lawyers for the accused persons, no asset tracing had been undertaken and no freezing orders had been obtained by my predecessors who filed the criminal charges. I could have been faced with a situation where the thief would have eaten 4 of the goats, thus leaving me with only one possibility, to recover only 2 goats. Alright? In other words, assets depreciate and may even disappear before a diligent prosecutor can lay hands on them. Now, those of you who have followed developments in the tracing and recovery of the assets of General Sani Abacha, you remember him, the Nigerian military leader who died, I think, in 1998. Okay? You will realize that, he shipped a lot of the assets overseas, mostly to Switzerland and other parts of Europe and the United States. As we speak, okay, from 1998 till now, the recovery process is still ongoing. And even with the sophistication of the Swiss authorities and the US authorities in collaboration with Nigerian authorities, recovery is still ongoing. So it is more complicated, than that. For people to think that it is just a question of the goats sitting there and for the Attorney General to say, bring all 6 goats back. But as I have crudely put it, if 4 of the goats have been used for live soup, how do you expect me, to retrieve the goats? Of course, jailing the person is also part of the process of accountability. And I do understand when Ghanaians say we should, jail them. But if we focus on the recovery, it will be very illusionary for anyone to think that the Attorney General or the Republic can recover 100% in every case. In some cases, I may be lucky, or let me say the state will be lucky if the assets are still there, they've not depreciated, they are there in full, and I can lay hands on them. That is how come that, if you have noticed since I came into office, we have always investigated the criminal conduct together with tracing the proceeds of crime. There has been no, except in the National Service case, there has been no major announcement of investigation that has not included the assets of the criminal enterprise. And in the National Service case, I want to let you understand that. You remember that the 4th Estate broke the story. Okay? The 4th Estate broke the story in October. The people who were involved knew that ultimate accountability would be exacted. So they would have, as rational actors, do you expect that the luxury cars they bought, the houses they acquired, all the assets, the bank accounts will still be staying intact, waiting for the prosecutor to come and then lay hands on them? No. So we are doing asset tracing in that case. But it has been very difficult because they started the process of hiding their assets way back in October 2024. But yet, I mean, we are coming upon a number of them, and I will make those available at the right time. Lastly, in respect of the case at hand, 100% recovery was not possible, and a conviction was not guaranteed. In the circumstances, my team and I agreed to set a realistic threshold of 60% recovery. Sorry. We recovered 824 million worth of assets, which will be handed over to the state, and established a structured pathway for recovering the additional 1.2 billion Ghana cedis through the civil, process. And these are monies that are being held by third parties that owed Unibank, including, for instance, and I think that this is very important, contractors owed Unibank at the time that it was placed in administration 2.9 billion Ghana cedis. Unibank made overtures to the state to say, look, the Minister of Finance, pay the contractors and let the contractors, because they will be paid through our bank, we can take the 2.9 billion and we can satisfy our books will, improve, and we can stay afloat as a bank. The then Minister of Finance flatly rejected that and put and with the help of the Bank of Ghana, put Unibank into the situation in which we find ourselves. All right? Our current finance minister could have put NIB through the same process, right? But instead of using money to collapse a bank, the Honorable Atuforsin has used the money to revive it, for it to keep jobs and then continue to operate in the banking sector. That is what is called wisdom in governance. Having explained my decision to enter a nolle prosequi in the case of the Republic versus Covenant before and others, I wish to provide a brief update on the investigations and prosecutions that are currently underway. Trials are commenced in the case of the Republic versus Covenant and 3 others, and that of the Republic versus Solomon Asamoah and another. That is the SkyTrain case. In the Covenant case, we are calling only 3 prosecution witnesses. Our first witness has concluded his testimony, but for the third accused person serving withdrawal in open court of a lawyer's service, our first witness would have been discharged to give way to the second prosecution witness to start testifying. We expect our second witness to start testifying before the beginning of the legal vacation on July 31st, 2025. In the SkyTrain trial, we have concluded the case management conference. It is important to add that, but for the change of solicitors and the multiple medical excuses of the second accused person, that is Prof. Ameyawe Kumfi, and recently of the lawyer for the first accused person, we would have called 2 of the 6 witnesses by now. That notwithstanding, the trial in the SkyTrain case is expected to start before the beginning of the legal vacation. The National Service Authority scandal case was due to be filed last week, as promised, when we stumbled upon evidence of malfeasance involving an account at the Bank of Ghana, to which had been transferred an amount of 189 million Ghana cedis. Out of this amount, 80 million Ghana cedis cannot be traced. But we found 2 checks bearing the name and account details of the former Director General, Mr. Osei Asibe, which had been used to withdraw funds totaling a little under 2 million Ghana cedis from the said account. We have therefore halted the filing of charges so as to await the receipt of the evidence from the relevant state agencies, including the Bank of Ghana, Ministry of Finance, and the Controller and Accountant General's Department. In fact, as I speak, the Bank of Ghana signaled to me that this morning they are going to deliver the. They were obviously interrelated in order to reach a unified resolution that will bring closure to all related matters. The objective was to assess the feasibility of a comprehensive settlement. The charges in the criminal case against the accused persons involved a total amount, and this is very important, a total amount of 1.2 billion Ghana cedis, not 5.7, as is being bandied about from certain quarters whose names I would not want to mention. Whilst the civil case involved a total exposure of 5.7 billion Ghana cedis. Now, ladies and gentlemen of the media, if you conduct your research in the High Court, you realize that the receiver subsequently amended the writ of summons and the statement of claim and revised the civil liability down to 2.8 billion Ghana cedis. Okay, so that is on record. That's a public record, and whoever wants to contest this is at liberty to go to the High Court and then do so. It is important to state for the avoidance of doubt that the total exposure in the criminal case is part of the total civil case exposure. In other words, the 1.2 billion is not in addition to or on top of the 5.7 billion, which was revised down to 2.8 billion. The charges in the criminal case against the accused persons involve a total liability. No, sorry, I think I'm repeating myself. Now, the 5.7 billion was made up of the following. That is from the initial, stage of the case. 2 billion being loans and advances which Unibank made to related and connected parties. 3.7 billion being payments made on behalf of or on the instructions of the accused persons. Included in A and B above, however, was an amount of 2.1 billion which was alleged to be fictitious loans, to have comprised fictitious loans and fictitious transactions booked by Unibank prior to the placement in official administration. During the reconciliation exercise, the accused persons objected to the inclusion of the 2.1 billion on the grounds that the amount did not involve any direct cash outflows which could be recovered. The accused persons also objected to the inclusion of placements of 0.3 billion, that is 300 million, made to Unisecurities. Now, Unisecurities is a Securities and Exchange Commission regulated, not a Bank of Ghana related company that had been placed in liquidation and for which a claim had been filed with the official liquidator. In other words, the money was to be recovered. The recovery of this amount is being pursued independently through insolvency proceedings with the official liquidator of that entity. In summary, the above matters led to the revision of the previously reported exposure of 5.7 billion down to 3.3 billion, which comprised the following. The exclusion of 2.1 billion in the alleged fictitious amounts booked to the account of the shareholder which did not involve cash outflows. In other words, monies didn't go out to anybody. These were just book entries that were designed to make the books of Unibank look good. That is how come that in the criminal case, the charge of falsification of accounts was brought against them. So they did not loot the money, they did not give the money to anybody. They just made entries that were meant to give Bank of Ghana, the central bank, the impression that the bank was doing well. Okay? Then the exclusion of 0.3 billion relating to Unibank's placement with a SEC-regulated, SEC-regulated related company currently in receivership, which is being pursued separately through the insolvency proceedings. After prolonged negotiations, the accused persons, by a letter dated 7th May 2025, made a proposal to settle the revised outstanding obligation of 3.3 billion Ghana cedis through a structured approach. The accused persons offered to pay 2 billion Ghana cedis in full and final settlement of the outstanding obligations through the following arrangements. 800 million worth of assets to be transferred directly to Unibank, which is in receivership, which will now make that available to the Bank of Ghana. And then their active cooperation and participation to assist the receiver to recover an additional 1.2 billion from the direct beneficiaries paid out on their instructions. Out of the above arrangements, the accused persons have provided landed properties valued at 824 million Ghana cedis to Unibank. That is, in receivership. Further, in other words, indirectly to the Bank of Ghana or the Republic of Ghana. Further, the accused persons will be responsible for any shortfall in the proceeds realized from the sale of the landed properties. A total of 0.5 billion has to date been recovered out of the 1.2 billion being pursued from the direct beneficiaries. Recovery of the remaining balance of 0.7 billion out of the 1.2 billion Ghana cedis and the realization of the landed properties provided are expected to be completed over a timeline of 18 months. Although the preference would have been for me and my team for the accused person to settle the proposed amount in cash, immediate settlement in cash was not, from my sense of what transpired at the negotiations, a realistic possibility or a realistic option. In assessing the proposal submitted by the lawyers for the accused persons, I took into account the following factors. The receiver of Unibank acknowledged that the fictitious amounts totaling 2.1 billion did not result from cash outflows, but related to accounting entries that overstated the asset base of the bank, which predated Unibank's placement in official administration. B. A claim for the placement of 0.3 billion with a SEC-regulated entity was filed by the receiver with the official liquidator in 2019, and its recovery is being pursued separately through the insolvency process. 3. Both the criminal and civil cases have persisted over 6 years with no immediate resolution in sight. The complex nature of the legal proceedings has significantly delayed any meaningful recovery. Now, come to think of it, those who instituted the criminal proceedings did not foresee the possibility down the line of recovering assets and never engaged in any asset recovery process. They did not trace to find out what assets were in the hands of third parties, including those who were in court. So while the criminal prosecution was intended to serve as a punitive and deterrent measure, it is through the civil process that actual recovery of funds is effectively pursued. The accused person's proposal fell within the receiver's mandate to maximize recoveries for Unibank in order to settle the bank's creditors, mainly Government of Ghana and some institutions.